I'm going to bring in my think tank tonight. Joining me here in studio, we have with us criminal defense attorney Ray Giudice, Assistant Chief Jailer Lieutenant Colonel Adam Lee, and criminal defense attorney Rachel Kaufman. Welcome to you all. We have one more guest joining us out in San Diego. Great criminal defense attorney out there. Vikas Bajaj joins us in San Diego, and he'll be with us in just a moment. So, all right, I want to go out to San Diego. Vikas Bajaj, criminal defense attorney, joining us. Vic, thanks so much for being with us tonight. We're talking about Matt Vaughn, who is the third person who is inside the room at the time of the alleged attack, not investigated, and does not testify for either side here. What's going on?
Well, if you're looking at this from Mr. Vaughn's point of view, it's an impossibility to actually testify. You are going to be damaged either way. If you testify on behalf of the prosecution, well, the prosecution itself would never want to call Vaughn, because Vaughn would have to deny the sexual conduct that Jane Doe is alleging occurred in this situation. He would have to. Otherwise, he'd be walking himself right into a conspiracy for a sexual assault, the same charge that Mr. Winslow Jr. is defending him against, himself against now. On the other hand, you have to understand that anyone who understands the consequences of coming into court, a live court case that has a ton of media, it can't be good. Once it says Mr. Vaughn on the TV, when many people don't listen to the words that may come out of our mouths, the association of an individual with this type of conduct is something that can never balance out on an opportunity cost. And of course, let's not forget that he is well within his rights not to testify, even if he was subpoenaed, because he has a Fifth Amendment right against self-incrimination. Now, the way to get around that, if we follow that road just a little bit farther down the line, the district attorney's office or any prosecutorial agency throughout the U.S., we see this, has an option. Well, Mr. Vaughn, I can give you immunity. Tell me what you have to say. I will give you immunity. You will never face criminal charges. Just tell us the truth about what Mr. Winslow Jr. said. And that's something the prosecution likewise will shoot themselves in the foot if they do that, because the question then becomes, how can you let someone who is so intimately involved in such horrendous allegations walk just to get testimony against Mr. Winslow Jr.? So getting his testimony and securing it, in my opinion, from the get-go has just really been a fallacy. I don't think that's a possibility.
Yeah, Vic, how does all this impact the jury? The fact that there's someone else in the room, there's a camera in the room, yet none of that now is part of the physical evidence in this case or testimonial evidence from these other people.
Well, number one, I don't think there's enough of a foundation for everyone to actually believe that there was a camera or a video recorder at the time. We have a statement that was somewhat flippant. Maybe it happened. I did remember it. But there's no actual evidence that this data can actually be assumed or acquired by anyone. But let me tell you this. In our state and all states around the union, one thing is consistent, okay? That is, if you have evidence, you still don't have an obligation to bring it, okay? And that is, you cannot assume it doesn't exist by it not being presented, but at the same time, the jurors are going to be given an instruction that says, if a person that has, or the party that has the ability to produce the evidence doesn't produce it, you can make implications in that regard. I think this issue on the videotape or the audio tape or the snapshots are irrelevant. It's a sideshow. I think it also lends a lot of credibility to the theory that this case has moved along too quickly. And let's talk about that for a second, because now we're in jury trial roughly a year after these allegations came about. Now, in this jurisdiction, having tried cases here and around the nation, I will tell you that that's very rare and that's odd. And so you have to believe that there was a strategic decision down the line, maybe based upon other DNA or forensic evidence that people did not want to come about, perhaps, that made this case push along so quickly. And there are some real deficits, and dare I say this as a member of the bar here in San Diego regarding my fellows, may I say that there's some evidence that should have been presented, an investigation that should have been done, such as the fencing
We're going to get to that in just a second, Vic.
That should have been
Vic,
presented much earlier.
It's like you're producing my show tonight. We're going to get to that fencing. We're going to talk a lot about that. Coming up also, folks, we're going to take you live outside the courthouse where Kellen Winslow II's trial is wrapping up. And again, the way, as Vic you pointed out, give him immunity. Obviously, the danger there for prosecutors is it looks like you're making a deal with a rapist, right?
Absolutely. You hit the nail on the head. That's exactly the problem. And let's look at this through the lens of the climate of certain types of prosecutions throughout the United States, and especially here in California. We are traditionally a much more liberal state generally, aside from a few very distinct conservative pockets. But you have seen, and I have seen over the past 20 years, how this type of prosecution has changed. And one thing we're not talking about is how easily a prosecutorial agency goes after these charges. It used to be the case that regardless of the law, practically speaking, that district attorneys, investigators would have their own screening process. Do they have enough to believe there's reasonable suspicion or probable cause or a good gut feeling, whatever the standard may be, to turn that over to a prosecutorial agency? And then the prosecutorial agency, of course, would comb through the forensic reports, the live testimony, or the percipient reports and say, well, do I have enough probable cause to file charges against, in this case, for instance, Mr. Winslow Jr.? Well, in this climate that we're in now, that is almost a death knell for any prosecutor who may be running for re-election anytime soon. Because you just practically you cannot attack or cross-examine a complaining witness's complaint, which is what I think leads to some holes in these stories.
All right, we got a lot more to talk about, folks, but I want to hear from you, our 13th juror. You know who didn't testify? That guy, Kellen Winslow II. This was a she said, he said case. Consent was supposed to be the defense, but Kellen Winslow II never got on the stand to say that. So, are you surprised Kellen Winslow II did not testify? Go to our Facebook page. Let me know. And there it comes in. Vic, let me ask you a question I ask a lot of criminal defense attorneys. Factual innocence versus, he's not factually innocent. Does that come into play in determining whether or not a criminal defendant should testify? Whether they actually did not do what they're accused of, and in this case, it's forcible rape. Does that weave into the equation on whether or not they should testify?
Oh, absolutely. And when you have facts that support a defense argument or a theory of the defense, well, then you can rely on the presentation of those facts and then dovetail all of that into an argument during closings with the jury instructions and say, well, we didn't have to testify. It's our given right not to, and you all know that, and you have instructions saying you have to do that. But that's all law. And even as a lawyer, as a trial lawyer, I will tell you, when you talk about the right not to testify, it goes in one ear and literally out the other. And I'm a defense attorney that should really have that imprint upon my mind. Now, this is what jurors do. Jurors understand that defendants have a right not to testify, but they don't like it. And the reality is, when you're talking about a case in that compartment that I would say includes domestic violence offenses and sexual assaults of every type and nature, if consent is an issue, you must, in my opinion. Now, let me also say that the attorneys here are doing a good job given the facts that they have, but you must call the suspect to testify. Otherwise, there's absolutely no hook to hang your defense hat on.
If I can interject, I would suspect that these are really good lawyers.
Absolutely.
And they've had their client out on bond. And let me tell you, when you've got your client on bond and he or she can come to your office anytime you want, and you can put him in a conference room instead of talking to him through the plexiglass window on the phone down there in the Gray Bar Hotel. Right. You can bring in a former prosecutor like Vinnie Balton and say, Vinnie, here's the case. Cross-examine him, and we're videotaping him, and we're going to see how he's going to do. We don't know how he did. I guarantee you.
Well, he was out on bond for a while.
That's right. Doesn't
For a
matter.
while.
But, it's a weekend, man. We make the coffee, baby. We're in there ordering pizzas. We can do this in 72 hours. And I assure you, these veteran lawyers had their client cross-examined by a former prosecutor, somebody. They called him or her up and said, come on and rip him up. And they didn't like how he answered the questions, or they didn't like the answers to the questions, or both. And that's why I didn't take the stand.
Who makes the decision?
Well, I think that obviously the defendant makes the decision, but I do think that it would have been more prudent, and maybe they did have a number of people come in and cross-examine him and make that decision, or I guess guide him to not testify. But I also think that if he didn't testify well and they felt, as a defense attorney in the situation where you're trying to prove consent, that they consented, I feel like you would need to maybe go a step further and see if some of his mannerisms or the way that he comes off could be softened. I mean, those are things that the way
They softened his look for sure. I mean, if you've seen the before and after when he was arrested and how he looks in court today, much, much, much different. All right, folks, want to hear what you have to say. Our 13th juror question. Are you surprised Kellen Winslow II did not testify? Yes or no? The question is posted on our Facebook page.